Today's webinar is co-organized by the Hong Kong Association of New York, the Hong Kong Economic and Trade Office New York, and eBRAM International Online Dispute Resolution Center Limited. I'm Rachel So, Director of Marketing and Communication of eBRAM, and the MC of today's webinar. It's glad to see so many of you taking the time to join us. Let me introduce Ms. Candy Nip, Director of Economic and Trade Office New York, to kick off today's webinar. Thank you, Candy.
Thank you, Rachel. Good morning, good afternoon, good evening, everyone. First of all, I would like to thank the eBRAM, International Online Dispute Resolution Center, and the Hong Kong Association of New York for organizing today's seminar. From the poll result just now, we are on a very interesting topic for sure. To me, ODR, Online Dispute Resolution, is not like a new creation. If my background research is correct, it was a product in the 90s, actually, when e-commerce first started to boom. But in recent years, ODR and other law tech applications have definitely picked up momentum in unprecedented ways. As one of the world's major business centers and a city with a strong legal profession, and ranked as the third most preferred seat for arbitration globally, Hong Kong naturally partakes in these exciting developments. So, what exactly is happening in Hong Kong on ODR? I would just like to take a few minutes to briefly highlight some key developments to set the scene for today's discussion. First of all, the eBRAM Center, it was established in Hong Kong in 2018. By integrating technologies such as blockchain, smart contract, and artificial intelligence, eBRAM provides a one-stop platform for online deal-making and resolving disputes among international commercial parties. It offers an economical and efficient option for global businesses and also improves accessibility to justice. In April 2020, Hong Kong opted into the Asia Pacific Economic Cooperation, or APEC, collaborative framework on ODR of cross-border business to business disputes. This framework promotes the use of ODR for micro, small, and medium-sized enterprises in APAC economies. The eBRAM Center is among the first batch and the only ODR provider from Hong Kong under this framework. In 2021, in collaboration with the United Nations Commission on International Trade Law, we set up the Inclusive Global Legal Innovation Platform on ODR to keep track of the international ODR landscape and develop legal tools to address potential issues. And this year, we launched the Hong Kong Legal Cloud in March. That marked another milestone for Hong Kong. This online portal provides a safe, secure, and affordable data storage services for the local legal and dispute resolution sectors, thereby enhancing the capability of the profession to make use of modern technology in the provision of relevant services. I'm sure you will agree with me. These are all very exciting developments. I'm going to stop here and we'll pass the floor to Dawn and our two expert speakers, Emmanuelle and Chris. I'm sure today's discussion will be a fascinating one. Thank you very much for joining us today.
Thank you, Candy. Today, before I pass the floor to Dawn, may I repeat the topic of today? Today's topic is from alternative dispute resolution (ADR) to online dispute resolution (ODR). Without further ado, may I pass the mic to our moderator, Ms. Donald Moore, Chairman of Hong Kong Association of New York. Over to you, Dawn.
Thank you, Rachel, and thank you, Candy, for the good introduction on what's happening in Hong Kong and ODR. As was mentioned, my name is Donald Moore. I'm the chair of the Hong Kong Association of New York. I've been doing that for about 5 years. In my everyday life, I'm managing partner of U.S. Legal Advisors, PLLC, and I do global security, transportation, infrastructure work. But today, I'm the moderator for the discussion about eBRAMs. And I find that to be a very innovative dispute resolution system, especially for the smaller disputes that are really abundant around the world, but sometimes don't have an affordable and practical system for resolving them. So I see it as sort of a small claims court for arbitration, and we'll hear more about that soon. We have two speakers today on our panel. Ms. Pui-Ki Emmanuelle Ta, or she goes by Emmanuelle. She's the CEO of eBRAM, and I'll give you a little bit more information about her soon. And Mr. Chris Healy, he's a partner in Duane Morris, and he's also going to be on the panel. So Emmanuelle is the CEO of eBRAM. Full name is eBRAM International Online Dispute Resolution Center. We call it eBRAM. Prior to becoming CEO, she had a very successful career in the International Court of Arbitration, serving in Paris and Hong Kong for the ICC, a total of over 15 years of arbitration experience, and handled hundreds of cases of arbitration. So very well qualified to be speaking to us today and to be leading eBRAM. Chris is a partner in the global law firm of Duane Morris. Founded in 1904, has over 800 attorneys and 25 offices around the world. I personally know Chris for quite some years. He's an expert in litigation and arbitration. Over 25 years, I think, is about right for Chris's professional career across many state and, of course, federal courts and arbitration in the U.S. and around the world, including Hong Kong and Asia. And he has a wide range of clients and industries. So Chris is also going to be very appropriate for our conversations today. So we're going to start next, and Emmanuelle is going to give us a presentation about eBRAM, and then we'll proceed with the panel after that. Emmanuelle?
Thank you very much, Don, for the kind introduction. I would like to start with some preliminary remarks on today's topic, from ADR to ODR. As we all know, technology can assist parties and tribunals during the arbitration proceedings. And during the COVID-19 pandemic, we have all experienced how technology has been able to help us overcome travel and COVID-19 restrictions. We have used video conferencing platforms to conduct meetings and have become more confident with technology. With that in mind, why not using more technology in other aspects of the arbitration proceedings to make it more efficient and cost-effective? Second, traditional ADR mechanisms are not necessarily suitable for the resolution of certain disputes or certain types of disputes, in particular low-value disputes or non-complex cases. Disputes with high-value claims sometimes can be straightforward and could be resolved in a very short period of time. However, processes governed by traditional arbitration rules do not necessarily allow the parties to adopt a fast-track procedure or depart from the institution's rules. The procedure being conducted in accordance with the institution's rules, these rules would apply regardless of the parties' agreement to conclude the case, for instance, in 3 months' time. The institution usually retains the right and the discretion to extend any time limits under its rules. So the longer the procedure takes, the higher the legal cost would be. Now, the question is, what can the parties do to expedite the proceedings, and what can they do to reduce costs while continuing to enjoy the same quality of arbitration services? Let's start by defining what ODR means, online dispute resolution. Next slide, please. The Ancestral Technical Notes on ODR, published in 2016, defines ODR as a mechanism for resolving disputes through the use of electronic communications and other information and communication technology. ODR can assist the parties in resolving disputes in a simple, fast, flexible, and secure manner without the need for physical presence at a meeting or hearing. ODR can therefore be described as a dispute resolution process where all aspects of the proceeding are conducted online through a platform, from the filing of the request for commencement of proceedings to the settlement of the dispute. The UNCITRAL technical notes also recommend using an ODR proceeding consisting of 3 stages: negotiation, mediation, and arbitration. Now, who can use ODR? Any companies having cross-border disputes wishing to resolve their disputes quickly and cost-effectively can use our platform. So today I'd like to introduce 2 ODR platforms developed by eBRAM. And before I do so, I will just say a few words about our organization. As mentioned by Candy earlier in the opening remarks, eBRAM is a nonprofit law tech center and ODR institution based in Hong Kong. It was established in 2018 with the support of the Asian Academy of International Law, the Law Society of Hong Kong, and the Hong Kong Bar Association. And our vision is to offer a one-stop shop for commercial parties from all over the world by providing a deal-making, dispute avoidance, and dispute resolution online platform integrating the latest technology. And eBRAM currently provides ODR services to the Hong Kong community through its COVID-19 ODR platform, and to all businesses around the world seeking fast and fair online resolution of disputes through the APEC ODR platform using a 3-stage proceeding or by arbitration in accordance with eBRAM's arbitration rules. eBRAM not only provides ODR services, but it also administers cases like other arbitral institutions to ensure that the ODR process is conducted in accordance with eBRAM's ODR rules. eBRAM is also one of the 6 qualified Hong Kong-based institutions under the Hong Kong-China Mutual Arrangement on court-ordered interim measures in aid of arbitral institutions by the mainland courts. This means that parties to an arbitration seated in Hong Kong and administered by eBRAM may seek interim relief from the Chinese courts against mainland-based counterparties. And prior to this arrangement, the domestic laws of the PRC provided no mechanism for a court to grant interim measures in a foreign arbitration. So this arrangement gives eBRAM a unique status as the first and so far the only ODR institution qualified under the mutual interim measures arrangement. So a party to an eBRAM's arbitration can apply for interim relief seeking property preservation or evidence preservation or conduct preservation under PRC law. Now turning to eBRAM's ODR platform. It is a technology-based platform with a human element for the administration of the cases and the decision-making. While other platforms available in the market may only offer partial online services to the parties, such as a case management portal or online hearing facilities or a portal to e-file a claim, eBRAM offers a fully fledged platform. So from the filing of the claim up to the settlement of the dispute, either by mediation or arbitration or negotiation, everything will be conducted online through the eBRAM platform and centralized in one place. With regard to our platform features now, our platform is equipped with advanced technologies and features, including blockchain and eKYC, which is the Know Your Customer technology. So all document transfer logs are stored in blockchain-enabled immunity storage when exchanged on our platforms. The eKYC technology will be used for first-time registrations to verify the identity of the parties before they can use our platform. In addition, the platform offers a highly secured video conferencing system, allowing meetings and hearings to be arranged anytime on the platform, a communication box, providing parties and neutrals with a convenient communication channel. Parties can also use the AI machine translation to translate any documents uploaded onto the platform into their preferred languages. The platform also includes a calendar for all relevant dates and deadlines, an online and secure payment system, and an e-signing system. Next slide, please. eBRAM offers 2 alternative mechanisms for companies to resolve commercial disputes, either by way of an expedited 3-stage ODR proceedings via the eBRAM APEC ODR rules, or under eBRAM's arbitration rules on the eBRAM arbitration platform. So I'd like to mention the initiative undertaken by APEC to help global businesses to resolve cross-border commercial disputes by ODR, with micro, small, medium-sized enterprises as the major beneficiary. In response to APEC MSME's need for affordable and effective dispute resolution means, the APEC Economic Committee endorsed in 2019 the APEC Collaborative Framework for ODR, which is designed to promote business-to-business cross-border confidence by providing quick online resolution and enforcement of disputes across borders, languages, and different legal jurisdictions. In May 2020, eBRAM was officially listed by APEC on its website as one of the very first batch of ODR service providers under the APEC framework. eBRAM also published a new version of its APEC rules, providing for more efficiency and transparency of the proceedings conducted under eBRAM ODR platform. Now, what are the conditions of application? Sorry, go back to the previous slide, please. Yes. So what are the conditions of application? All businesses in APAC and worldwide can use the eBRAM platform to resolve their disputes in accordance with the eBRAM APAC rules, regardless of the amount in dispute. They must agree to refer any disputes to be resolved by ODR under the eBRAM APAC rules. In terms of procedure, the eBRAM APAC rules provides a one-stop shop for online negotiation, mediation, and arbitration. In terms of the ODR process, next slide, please. Parties shall first commence online negotiation proceedings within 10 days. And if the parties can't settle, a neutral will be appointed by eBRAM to mediate the dispute. And such appointment shall be made by eBRAM from its panel of neutrals, which comprises multilingual international commercial dispute resolution professionals coming from different jurisdictions and with expertise in a variety of sectors. So from the appointment of the neutral, the parties will have 10 days to reach a settlement agreement. And failing a settlement of the dispute, the proceedings will move to the arbitration and final stage, which will take around 20 days until an arbitral award is issued. So to reach conclusion, the whole process will take only 2.5 to 7 weeks. Now, how about cost? In compliance with the APEC ODR framework, the cost of the proceedings conducted under eBRAM's APEC rules are reasonable and affordable. For disputes with an amount up to $100,000, no filing fee will be charged and the neutral fees will be capped. For example, for a $75,000 claim, the eBRAM administrative fees is $760, so around 1% of the amount in dispute. At the mediation stage, the neutral will receive a fixed fee of around $500, inclusive of preparation and up to 4 hours of mediation. Up to the arbitration stage, with the issuance of a final award, the neutral will receive a fixed fee of 10,000 Hong Kong dollars. And for a $630,000 claim, the initiating party will be required to pay a filing fee of $630 and $4,200 as administrative fees. And the neutral will receive an hourly rate of not more than $400. So now turning to the APEC model clause. So to resolve disputes by ODR under eBRAM's APEC rules and on the eBRAM APEC platform, the parties must have agreed to settle any disputes arising within the scope of the APEC ODR framework in accordance with eBRAM APEC rules. They can simply include eBRAM's model clause into their contract or agree in writing after any dispute has arisen. There is no requirement as to the nationality or location of the parties. Next slide, please. So we have a dedicated web page explaining the APEC ODR process. To start a case, you simply need to create an account on the APEC ODR platform and file your claim and upload your supporting documents online. Next slide, please. If you want to know more about the APEC ODR platform or about our rules, they can be found on our website. You may just scan the QR code appearing on the screen to access the relevant web page. Now let's turn to the second alternative for resolution of dispute by online arbitration. The newly launched, next slide please, the newly launched platform developed by eBRAM is the online arbitration portal. For parties to use the eBRAM arbitration platform, there must be an agreement to arbitrate any disputes under the eBRAM arbitration rules. Such consent can be found in the arbitration agreement contained in the parties' contract, on the basis of which the notice of arbitration will be filed, or parties may subsequently agree after a dispute has arisen to use eBRAM arbitration rules and platform to resolve their disputes. eBRAM's model arbitration clause can be found on our website and in our rules and can be considered by the parties when negotiating a contract. To file a claimant party is required to register an account on the eBRAM platform and complete its request for arbitration online. The arbitral proceedings will then be conducted in accordance with eBRAM arbitration rules and administered by eBRAM Secretariat. The arbitration case will be submitted to a sole arbitrator or a three-member tribunal. If the parties do not agree on the number of arbitrators, eBRAM will fix the number based on the circumstances of the case. So now the procedure under the eBRAM APEC rules. The online arbitration adopts a streamlined process. To commence proceedings, the claimant shall submit a notice of arbitration on the eBRAM platform. Respondent would then have 30 days to submit its response. The proceedings are to be conducted by a tribunal composed of 1 or 3 arbitrators, and failing the parties' agreement, eBRAM will decide on the number of arbitrators. When the appointment of the arbitrator is to be made by eBRAM Center, a suitable candidate will be selected from eBRAM's panel of arbitrators, comprising of experienced international arbitration practitioners. Once a tribunal has been constituted, the tribunal has conduct of the proceedings and shall proceed with the establishment of the procedural timetable. The arbitration rules provide in this regard that the arbitral tribunal shall fix time limits not exceeding 45 days for the submission of the written statement of claim and statement of defense. Parties and tribunal shall then decide whether or not to hold an online hearing. And after the hearing, and after hearing the parties and receiving the parties' submissions, the tribunal shall proceed with the closing of the proceedings and draft the final award. A draft award shall first be submitted to eBRAM for review to enhance the validity and enforcement of the award. At the end of the proceedings, a final and binding award rendered by the arbitrators will be notified to the parties through the platform. Now, what are the specificities of an eBRAM arbitration? 3 words: efficiency, flexibility, and transparency. In terms of efficiency, all aspects of the proceedings are to be conducted online within a secure environment. Arbitral tribunal shall conduct the proceedings so as to avoid unnecessary delay and expense and to provide a fair and efficient process for resolving the parties' disputes according to Article 17.1 of the rules. And in terms of flexibility, the number of arbitrators, the identity of the arbitrators, and the place or language of the arbitration can be decided by the parties and agreed upon between the parties. The rules are very flexible and flexible enough to accommodate the parties' needs in this regard. The place of arbitration according to the rules is Hong Kong, unless the parties agree otherwise. The language should be determined by the tribunal unless the parties agree on the language of the arbitration. And hearings are to be conducted on the eBRAM platform by video conferencing unless the parties request to hold a hearing in person or use a hybrid format. In terms of transparency, parties know upfront the amount they would need to contribute for the resolution of their disputes using our cost calculator. And eBRAM's list of arbitrators is also published on our website so that parties can choose an arbitrator from the panel, or they know who are our arbitrators. In terms of time limits, this is also another important issue. In all eBRAM proceedings, parties are free to agree on any particular time limits in the arbitration agreement. But the average duration of an arbitration conducted under our rules is less than 6 months. Article 17.1 provides that the arbitral tribunal shall conduct the proceedings so as to avoid unnecessary delay and expense and to provide a fair and efficient process for resolving the parties' disputes. Article 25 states that the periods of time fixed by the arbitral tribunal for the communication of written statements, including the statement of claim and statement of defense, should not exceed 45 days. However, the tribunal may extend the time limits if it concludes that an extension is justified. And finally, according to Article 41.2, eBRAM shall determine the fees payable to an arbitrator in accordance with the eBRAM schedule of fees. So in determining the fees, eBRAM shall take into account the amount in dispute, the complexity of the subject matter, the time spent by the arbitrator, and any other circumstances of the case, including the diligence, efficiency of the arbitrator. So eBRAM has control over the efficiency of the procedure and making sure that the tribunal will comply with the time limit under the rules. In terms of arbitration cost, our cost calculator will generate the amounts of eBRAM's administrative expenses and the arbitrator's fees after inputting the amount in dispute. So all our costs are calculated based on the amount in dispute. So for a $130,000 claim, the claimant will be required to pay a filing fee of $630 and $2,300 as administrative fees. So it's around 2% of the amount in dispute. And for a higher amount in dispute, around $5 million claim, the administrative fee will be around $21,500, so less than 0.5% of the amount in dispute, while the arbitrator's fee will be capped at $800. Let me now give you a quick walkthrough of the features you may find on the arbitration platform developed by eBRAM. So it is a fully fledged platform that offers more than a case management platform. In addition to the communication box, the file storage and exchange, eBRAM offers other distinctive features such as a video conferencing room for online hearings with breakout rooms, an AI machine translation to translate legal documents, online payment options to facilitate the payment of the arbitration fees, and an e-signing system allowing multiple parties to sign on the same document at the same time on the platform. Now, I'd like to make few more comments or expand a little bit about the Hong Kong China interim measures arrangement that I've just mentioned earlier at the beginning of my presentation. eBRAM has been named as one of the 6 qualified institutions under that arrangement, and this is another key element that parties must consider when choosing arbitration rules or ODR providers. With this arrangement, interim measures applications against Chinese counterparties in a Hong Kong-seated arbitration are now permitted. But this comes with certain conditions in respect of the seat and the administration of the case. So to benefit from this arrangement, parties must agree to an arbitral proceeding seated first in Hong Kong and administered by one of the 6 qualified institutions based in Hong Kong, including eBRAM. So eBRAM is so far the only ODR provider qualified under this arrangement. Now, why resolve your disputes with eBRAM? Because eBRAM offers a reliable and secure platform that complies with international cybersecurity standards. Remember, I said eBRAM is a law tech center and an ODR center and an ODR institution. So independent tests and total system audits, including cybersecurity assessment, are conducted regularly by external certified security experts. Our platform is also protected by the highest level of cloud security, including firewalls and intrusion detection. Security measures adopted by eBRAM, for instance, include a multi-factor authentication for all users' accounts, including a verification code sent to users every time they log in. And for first-time registrations, we will use the eKYC technology to verify the identity of the user by requiring the user to scan a copy of his or her ID card or passport. In terms of security, all data is encrypted with bank-grade encryption during transmission and cloud storage. The data will be kept in secure cloud environment that is fully controlled and managed by eBRAM and not by third parties. eBRAM's handling of personal data is in accordance with the requirements of the Hong Kong Personal Data Privacy Ordinance. We also comply with the relevant requirements under other data protection laws of other jurisdictions as and where applicable. Finally, to learn more about eBRAM, you may wish to scan the QR code. And if you would like to have a free trial of our e-signing system, I invite you to scan the other QR code. Thank you very much for your attention.
Great. Thank you, Emmanuelle. Excellent presentation. And boy, it really raised a lot of questions for me. But I want to note, because I didn't before, anybody who's watching can please submit their questions in the public chat room, and we will do our best to get to them. So before I get to any of my questions or any of the public questions, we're going to turn to Chris. Chris is going to give us a bit of overview of his perspective of perhaps ODR and eBRAMs and maybe kind of a US or a non-Hong Kong perspective. I don't know. Chris, please give us your thoughts, and then warning people, we might run a little bit over, I suppose, based on this time, but we'll see how many questions we have, and we'll try to keep within the time. Go ahead, Chris.
Great. Don, thank you, and thanks for the introduction. Hello to everyone. I'm going to keep this very, very brief so that we can get into the discussion portion of the program. My clients typically pay me to solve problems, and that's as sort of basic as it gets with regard to sort of what I do day in, day out. I like to say that none of my clients are in the dispute or litigation business. It's not what they do. None of my clients want to be in dispute or litigation with a business partner in particular. So anything that can be done to find quick, efficient, cost-effective, and above all, confidential solutions to resolving disputes is a potential game changer. So with that said, Don, I think I'll turn it back over to you, and we can just sort of launch into a discussion, whether it's questions from the audience, questions from you, et cetera.
Okay, great. Well, we had a couple of topics that we kind of maybe mutually agreed upon to begin with, and it's kind of a discussion on common issues and deficiencies with traditional arbitration and how this type of ODR and eBRAM system may actually help overcome that. So probably keep these short because we probably got a number of questions, but I'd put that first to the panel.
Sure. Emmanuelle, do you want to take a swing at that first?
Sure, happy to. So as I've mentioned in my presentation, I think I've touched upon a little bit, in the beginning of the presentation about the issues that that we are facing with traditional arbitration, right? That is cost and time. And maybe I want just to recall that arbitration was initially, established to actually be an alternative to litigation to overcome the time and cost issue arising out of litigation. However, over time, arbitration has become costly and lengthy due to the fact that parties now tend to conduct arbitration proceedings the same way as they would conduct litigation proceedings. And the average duration of an arbitration is now between at least 18 months to maybe 2.5 years. So arbitration proceedings may also be delayed due to the parties' many extension requests or the tribunal's delay in rendering the award. So I think now we have another alternative to alternative dispute resolution, that is ODR, because so I think ODR can overcome all these challenges that I've mentioned and and reduce significantly time and cost by providing a platform for the parties to communicate and exchange within a secure environment, and provide them with law tech tools such as an e-signing system or an AI machine translation to translate documents easily, that is integrated into the system for the parties' use and with no additional charge. So that is something that we were looking into more closely to really help the parties overcome the language barriers, for example, or the geographical barriers, so that they can have access to justice. They can meet anytime through the platform, and using the video conferencing for the hearings, for example.
And Emmanuelle, I'll just sort of jump in there and just echo some of what you said from a practice point of view. I think arbitration in many ways is now as expensive as litigation can be, and certainly in some instances will take as long as long a process as litigation can be, depending on the type of dispute, depending on where that dispute is being arbitrated. Obviously, the one advantage to arbitration over litigation is confidentiality. Typically in the arbitration setting, confidentiality is automatic, whereas in a litigation setting, it's typically not. And sometimes there has to be some negotiation or wrangling or application to a particular judge in order to get confidentiality to apply to certain materials, ideas, thoughts, concepts, etc. So I think in some ways, and I'm just going to be really honest about it, I think traditional arbitration has lost its way a bit. And so anything, again, that can be done to sort of put plaintiffs and defendants on equal footing in terms of a settlement path, I think is a great idea, especially in what I will call the COVID, post-COVID world.
Oh, you just got muted there, Chris. Either yourself or somebody.
Okay,
There we go.
sorry about
You're
that. I was just, the last point I'll make on this is, I think online dispute resolution is certainly topical in the post-COVID world that we live in now. Most everyone is comfortable with video technology, and I think platforms that encourage those kinds of discussions to take place by video with some rules of the road along the way just make it easier for parties in dispute to resolve their issues, especially for smaller type disputes.
Mm.
All right, good. All right, I had a couple maybe categories of questions. One of them was the initial targeted jurisdictions that eBRAM's looking at. I'm assuming if it's APEC originated, you might say, it's going to be fairly Asia and it's focused, at least for one party probably to the dispute, I'm guessing. But maybe you can tell us about that. And also on the neutrals, you told us a little bit about how the neutrals are chosen, the arbitrators and so on. Does that person typically need to be an APEC resident, or is there any provision about that?
No, so actually we welcome applications from any, mediators or arbitrators from all over the world, because they have their own expertise, their background. We need all of them to get in our panel so that we can find a suitable candidate, to conduct the case for any ODR case that will be received by eBRAM. So we do not look, we want diversity in our panel as well. So, and especially because if we want to resolve APEC cases involving a particular claimant in Asia, we will certainly not have someone of the same nationality, for example, right? We will find someone that is independent and neutral. So we'll look for an arbitrator or mediator that is of a different nationality. So there's no limitation as to the nationality of origin or geographical region. We are welcoming any applications from any neutrals. And in terms of the national of who can use our platform, there is no limitation either. So it was intended to be an APEC focus, right, for businesses in APEC to benefit from this framework, but it has been extended to all businesses around the world. If they find it suitable, we actually want to promote ODR so it can be used by any businesses of any nationalities.
And John, let me just jump in there and just say this too. From the outside lawyer view, I think for online dispute resolution to be successful and for lawyers to recommend it to their clients, there needs to be a deep tribunal bench. There needs to be diversity in that bench. There needs to be diversity of views, of experiences and expertise. You may arbitrate a claim in Hong Kong applying New York law with New York lawyers on one side and English lawyers on the other. So you have to think, you have to take all of that into account, I think, when you're sort of putting your tribunal pool together, because I know as the outside lawyer, we're looking at that. We want that. We want to try to find the best possible people to be put in roles of decision making so that we get the best possible outcome and results for our clients.
Excellent.
And maybe
Go
I'm
ahead.
sorry, can I just jump in and make a comment? Actually, I just wanted to clarify also that all arbitration proceedings conducted under our rules and on our platform are not governed by Hong Kong law, for example, but the parties are free to choose any applicable law.
Right, exactly.
Yeah.
So maybe a little bit extension of that topic is, I think your presentation referenced APEC arbitral award enforcement. How does that fit into the sort of more global New York Convention, which has 170 members to that? I don't really know the APEC rules for enforcement. Maybe they actually refer over to the New York Convention. Any comment from either side about how that works or doesn't work?
Yeah, actually, the APEC, our APEC rules are based on the APEC model rules, procedural rules that are then in turn based on the UNCITRAL technical notes, who actually provide for a three-stage proceeding. So, so it's not something that has been, published just by eBRAM. We actually base our rules. We use actually the APEC model procedural rules to establish our own rules, and our awards, that are issued, under the APEC rules are of the same validity as any other awards rendered under other institutional rules. There's
Right.
no
I guess I was
difference.
trying to, because all the APEC members are also members of the New York Convention. So I was trying to figure out if
That's correct. And actually APEC also includes the United States. So
yes.
it's not just Asia, but we have
No,
also
sure.
United
Yeah, that
States and
was,
some
yeah.
countries in some economies in the in South America as well. So, but yeah, that's why I want maybe to point out again that it's true that we call it the APEC rules because it was an APEC initiative, and it's based on the APEC collaborative framework for ODR, but it's something that can be used by any businesses around the world, again, not just for APEC. But then the title, we have that word APEC in the rules because it's an APEC, it's under the APEC framework.
Yeah, sorry, I probably misspoke. It's not Asia focus, it's Asia Pacific focus, which includes many, the U.S. and other American, North and South American countries. So, Chris, any additional thoughts on the enforcement issue?
Yeah, look,
at the end of the day, it's great to win, but you still have to get your money and you have to enforce it.
You've got to be able to enforce the award, and the way to do that is to take advantage of the New York Convention and those jurisdictions that have adopted the convention. So again, this is about what I will call appealability, right, to clients and their lawyers. Lawyers are going to be hesitant to go into a jurisdiction to mediate or arbitrate a dispute if that jurisdiction and those arbitral rules don't adopt the New York Convention.
Yeah. So great. So then, Emmanuelle, we briefly spoke before we went live about security and the cloud and all of that. I just think that's probably worth another, a little bit of further explanation because, of course, in today's online world, security is paramount, not just for the aspects of the litigation, but the confidential information that may be available about people's business generally and all of that. So maybe you can give us a quick summary of that. Chris, and you can comment on that.
Sure. So for ODR providers, data privacy, security, and confidentiality, as well as cybersecurity, are our priorities. And as a law tech center, we have to make sure that we are compliant with all data protection laws around the world, and we make sure that our system is compliant with all cybersecurity standards. So we are performing different tests and assessments for our cybersecurity, for our total our IT system. We conduct a review of our cloud security system as well, and we also perform an assessment on the privacy impacts, and make sure that there is no possibility for data to be leaked or there's any data breach as well. So in terms of security, all data will be encrypted with encryptions during the transmission of data and during storage in the cloud. And as I have mentioned, during storage in in the cloud environment, it is totally controlled by eBRAM and not by third parties, because it is safe in our environment. So we have access to that environment, and we control that and manage the operation of the system. We also handle personal data in accordance with all applicable data protection laws, including the EU GDPR, the Hong Kong privacy law, as well as the China protection of privacy law as well.
Yeah, good. I think that's really important. Chris?
And Don, again, just from the outside counselor perspective here, I always say winning and losing is really important to clients. And I can't speak to eBRAM's sort of technical capabilities. Emmanuelle has just done a fine job of that. But equally important as winning and losing to clients is confidentiality and data security and data privacy, especially when you're dealing with the rules in Western Europe, in particular, some of the US rules, et cetera. Very, very important that data security be wrapped up, and that if we're using eBRAM or another service per se, that service sort of ties in nicely with what we want to do in terms of maintaining confidentiality and data security.
Right. So we're getting close to the end of our time. Maybe a couple more questions. Chris, maybe for the US audience, maybe you can give a little primer to businesses who might be considering or international arbitration, but maybe have never done it, as opposed to litigation, for example, in the US, or even arbitration in the US. Some thoughts you can share with US businesses about that whole process and why that might be different for them.
Sure. Yeah, look, I think most US-based businesses are unfortunately familiar with the litigation process in the United States. Again, none of my clients are in the litigation business. I suspect that those of you who are participating today are likewise not in the litigation business. It's just not the product or service that you sell. That said, I think just very, very high level in terms of international arbitration, the sort of things that you want to be on the lookout for are, what is the operable or controlling law that is going to apply? Again, you can arbitrate something in Hong Kong or Singapore with English law, US law, et cetera. So you want to keep an eye on that, obviously. You also want to keep an eye on the arbitral rules. What are the sort of local rules of the road that are going to create the framework within which that mediation or arbitration is going to take place? The other important thing, and this is something that often doesn't get discussed, is language and language barrier for U.S. companies arbitrating in foreign jurisdictions. Language is often, and it can be, an issue, and whether it's Hong Kong, Singapore, Korea, et cetera, that has to be taken into account as well. And again, some of that has to do with who are the tribunals. What is the pool to choose from in terms of those tribunals? What are their experiences and levels of expertise? And then the last thing I'll sort of put in there, and this is attendant to language, is just local culture. What are the cultural issues that you as a foreigner arbitrating in a foreign jurisdiction need to be mindful of? And I don't think that can ever be understated or overstated enough. You need to take that into consideration when looking to retain outside counsel, when looking to adopt a particular arbitral service, et cetera. All of those factors play into the ultimate outcome. And again, these are where I tend to focus client conversations when we talk about arbitrating overseas.
Great. And so then the earlier part of the comments you just made lead me probably to my last comment or suggestion, and that is, none of that happens unless your contracts have the appropriate language committing to an arbitration and committing to, for example, the eBRAM arbitration process and rules. And so it's really critical that you get that language in there and get it right, because when people are in dispute, they usually don't nicely sit down afterwards and agree about what the arbitration is going to be. That usually is not the time for a nice conversation, probably. And so, Emmanuelle, maybe you can reemphasize and point to the location online where people can get that language. That's really critical to have in, and then of course they need counsel to help advise them, make sure that it's not all just copy and paste, but that's certainly the start of where do they get that language to get into the eBRAM system, you might say.
Yeah, thank you very much, Don. This is a very good point. So our model clauses, so for the APEC ODR process or for the mediation process or the arbitration process can be found on our website. And they're also, the model clause are also attached to the rules. So if you look up the rules, the relevant rules, so the APEC arbitration mediation, you'll find a copy of the model clause at the end of the rules. And of course, we are available for the parties if they have any questions regarding how to draft that arbitration clause. We can, help them throughout the process. So parties need to insert an arbitration clause or mediation clause or the APEC clause into their contract when they negotiate that with the other side. And if they have not done so and they currently they are facing a dispute now, they can still use us. If both parties agree to use us, they can always come to us after a dispute has arisen. So there's also an option to come to us even though the contract does not foresee any arbitration proceeding under eBRAM's rules. Thank you.
Hey, Don, let me just one, I can't help but just sort of speak to this topic just really, really briefly. I typically get involved after the fact, after there's a problem, a dispute, an issue, and then I get to take a look at the ADR provision that's built in to whatever agreement or contract is in dispute. And I would recommend to everyone listening in today that at the time of drafting, that's the time you really need to think about your choice of law and ADR provisions in your agreements and contracts. And I always recommend that you show those provisions in draft form to a litigator or someone experienced in that world. I find more often than not that the ADR and choice of law provision is an afterthought in many of these agreements, and they are usually deficient. And it usually leads to problems and issues between litigants in the context of a dispute because there isn't enough information and position and direction put into that ADR provision. So I think, again, tracking with what Emmanuelle said, getting a good provision in your agreement is really the best thing that you can do to point yourself in the right direction in the event of a dispute with a contracting party.
Yeah, and then I would say note to lawyers, I'm a corporate transactional lawyer, so most lawyers think they know what they're doing. And they just go, oh, there's the provision. We'll put it in there, and that's great. What you should do is go to your partner who's a litigator and say, all right, does this actually work in this instance? And get a little, so you need a little more advice to the corporate legal crowd than, you should include your litigation partners in understanding that.
Agreed.
As a litigator, I'm sure you agree. So.
Yeah, Don, look, I've seen it with very large, sophisticated clients. You'll look at an agreement, you have an ADR provision and choice of law provision, and there are internal conflicts within those provisions.
Yeah.
That just don't make sense because, again, this was an afterthought. Someone took some boilerplate language, they plugged it into the agreement, presumed it would work, but in the real world, it just doesn't work that way.
That needs to be tweaked. So I think that'll wrap up unless you guys have any particular additional points you'd like to make. Want to say thank you to everybody who's helped put this together. Justin So and Emmanuelle Pui in the background. You haven't seen them, but they worked very hard to put this together. Also, thanks to Rachel and Candy, Emmanuelle and Chris for participating and making the event happen. Very pleased on behalf of Hong Kong Association of New York to be supporting this, as well as the ETO who's given their support in all of our events. If you're interested in any of our events, you can go to hkany.org or contact myself or Michelle. We have events on a regular basis. And that is it. Thanks for everybody for the participation, for watching. And we'll be posting online so you'll be able to see it again or share it with others who didn't get a chance to see it. So Thank you so much. Have a great evening and a great morning, and we'll see you next time.